you like to become a communist? Just think it. You too. Communism.
Thanks, I guess.
Sir, would you like a communism packet? No. No. No, you need 2 communist packets. You look like a communist.
Alright, thank you.
Oh, and you look like a communist. Here, you can
Get away.
Sir, take this packet.
Oh,
Awesome, thank you.
thank you.
Communists don't like girls, but it's okay.
Okay.
Don't forget about you. You need one too. Hooray for communism.
Katniss, I believe in you. I think you can take this Hunger Games.
Do
I do. Like, your biggest challenge is going to be killing PETA. You have to kill PETA
Why?
because I need you to win. You have to have a bet going with Portia.
I can't kill Peter. I love him.
But I love Portia. That doesn't make a difference. I'd kill her.
I thought you were gay.
What? Gay? How?
Well, I mean, look what you wear. And your personality and your face.
I mean, yeah, I kind of could be gay, but no. Alright, let's go figure out your outfit.
Okay.
Hooray for communism.
Hey, you can't do that.
Wait, then drop. Ah!
Please read the opening statement.
Benjamin Gitlow was indicted in the Supreme Court of New York with 3 others for the statutory crime of criminal anarchy. New York Penal Law 160-161.1. He was separately tried, convicted, and sentenced to imprisonment. The judgment was affirmed by the Appellate Division and by the Court of Appeals, People v. Gitlow. The case is here on writ of error to the Supreme Court, to which the record was remitted. The contention here is that the statute by its terms and as applied in this case. It is repugnant due to the due process clause of the 14th Amendment. The indictment was in 2 counts. The first charge that the defendant had advocated, advised, and taught the duty, necessity, and priority of overthrowing and overturning organized government by force, violence, and unlawful means. by certain writings therein set forth entitled The Left-Wing Manifesto. The second, that he had printed, published, and knowingly circulated and distributed a certain paper called The Revolutionary Age, containing the writings set forth in the first count advocating, advising, and teaching the doctrine that organized government should be overthrown by force, violence, and unlawful means.
The following facts were established on the trial by undisputed evidence and admissions. The defendant is a member of the left-wing section of the Socialist Party, a dissenting branch or faction of that party formed in opposition to its dominant policy of moderate socialism. Membership in both is open to aliens as well as citizens. The left-wing section was organized nationally at a conference in New York City in June 1919, attended by 90 delegates from 20 different states. The conference elected a national council, of which the defendant was a member, and left to it the adoption of a manifesto. This was published in the Revolutionary Age, the official organ of the left wing. The defendant was on the board of managers of the paper and was its business manager. He arranged for the printing of the paper and took to the printer the manuscript of the first issue, which contained the left-wing manifesto and also a communist program and a group of the left wing that had been adopted by the conference. 16,000 copies were printed, which were delivered at the premises in New York City used as the office of the Revolutionary Age and the headquarters of the left wing, and occupied by the defendant and other officials. These copies were paid for by the defendant. As business manager of the paper, employees at this office wrapped and mailed out copies of the paper under the defendant's direction, and copies were sold from this office. It was admitted that the defendant signed a card subscribing to the manifesto and program of the left wing, which all applicants were required to sign before being admitted to membership. That he went to different parts of the state to speak to branches of the Socialist Party about the principles of the left wing and advocated their adoption, and that he was responsible for the manifesto as it appeared that he knew of the publication in a general way, and he knew of its publication afterwards, and is responsible for the circulation. There was no evidence of any effect resulting from the publication and circulation of the manifesto. No witnesses were offered in the behalf of the defendant. Extracts from the manifesto are set forth in the margin. Coupled with a review of the rise of socialism, it condemned the dominant moderate socialism for its recognition of the necessity of the democratic parliamentary state, repudiated its policy of introducing socialism by legislative measures, and advocated in plain and unequivocal language the necessity of accomplishing the communist revolution by a militant and revolutionary socialism based on the class struggle and mobilizing the power of the proletariat in action through mass industrial revolts, developing into mass political strikes and revolutionary mass action for the purpose of conquering and destroying the parliamentary state and establishing its place through a revolutionary dictatorship of the proletariat, the system of communist socialism. The then recent strikes in Seattle and Winnipeg were cited as instances of a development already verging on revolutionary action and suggestive of proletarian dictatorship, in which the strike workers were trying to usurp the functions of municipal government and revolutionary socialism. It was urged must use these mass industrial revolts to broaden the strike, make it general and militant, and develop it into mass political strikes and revolutionary mass action for the annihilation of the parliamentary state. The Appellate Division, after setting forth extracts from the manifesto and referring to the left-wing and communist programs published in the same issue of the Revolutionary Age, said, "It is perfect plain that the plan and purpose advocated contemplate the overthrow and destruction of the governments of the United States and of all the states, not be the free action of the majority of the people through ballot box and electing representatives to authorize the change of government by amending or changing the Constitution, but by immediately organizing the industrial proletariat into militant socialist unions, and at the earliest opportunity through this mass strike and force and violence, if necessary, compelling the government to cease to function, and then through a proletarian dictatorship taking charge of and appropriating all property and administrating it and governing through such dictatorship until such time as the proletariat is permitted to administer and govern it. The articles in question are not a discussion of ideas and theories. They advocate a doctrine deliberately determined upon a plan for militantly disseminating a propaganda advocating that it is the duty and necessity of the proletariat engaging in industrial pursuits to organize such an extent that by mass strike the wheels of government may ultimately be stopped and the government overthrown. The Court of Appeals held the manifesto advocated the overthrow of this government by violence or by unlawful means. In one of the opinions representing the views of the majority of the court, it was said, "It will be seen that this defendant throughout the manifesto advocated the destruction of the state and the establishment of the dictatorship of the proletariat. To advocate the commission of this conspiracy or action by mass strike whereby government is cooked, the administration of justice paralyzed, and the health, morals, and welfare of the community in danger, and this for the purpose of bringing upon a revolution in the state is to advocate the overthrow of organized government by unlawful means." And both the Appellate Division and the Court of Appeals had the statute constitutional. This is not the expression of philosophical abstraction, the mere prediction of future events. It is the language of direct incitement.
It's like, you don't do it like that. Just because they do it in the video doesn't mean anything.
How do you do it?
Can you tell if I'm doing it?
Here.
Please read the closing statement.
A state may punish utterances endangering the foundations of organized government and threatening its overthrow by unlawful means. These imperil its own... That doesn't make sense. Sorry.
That's okay.
These imperil its own existence as a constitutional state. Freedom of speech and press does not protect disturbances to the public peace or the attempt to subvert the government. It does not protect publications or teachings which tend to subvert or imperil the government or to impede or hinder it in the performances of its governmental duties. It does not protect publications prompting the overthrow of government by force. The punishment of these who publish articles which tend to destroy organized society being essential to the security of freedom and the stability of the state. A state may penalize utterances which openly advocate the overthrow of the representative and constitutional form of the government of the United States and the several states by violence or other unlawful means. In short, this freedom does not deprive a state of the primary and essential right of self-preservation, which, as long as human governments endure, they cannot be denied. By enacting the present statute, the state has determined, through its legislative body, that utterances advocating the overthrow of organized government by force, violence, and all unlawful means are so inimical to the general welfare and involve such danger of substantive evil that they may be penalized in the exercise of its police power. Presumption is to be indulged in favor of the validity of the statute. It cannot reasonably be required to defer the adoption of measures for its own peace and safety until the revolutionary utterances lead to actual disturbances of the public peace or imminent and immediate danger of its own destruction. But it may, in the exercise of its judgment, suppress the threatened danger into its incapacity. I don't know that word. Incipiency?
Yeah.
Incipiency.
The decision was, we need not enter upon a consideration of the English common law rule of seditious libel or Federal Sedition Act of 1798-11, to which reference is made to the defendant's brief. They are so unlike the present statute that we think the decisions under them cast no helpful light upon the questions here. And finding for the reasons stated that the statute is not itself unconstitutional, and that it has not been applied in the present case in derogation in any constitutional right, the judgment of the Court of Appeals is affirmed.